You know, today we are increasingly seeing companies merge or spin off divisions or sell a group of their assets. And when those kind of changes arise, many fail to consider what are the immigration consequences and what must be done to comply with immigration law. Oftentimes, a transaction like that, a merger or an acquisition, takes place because there are some people that are very valuable because of their skills and their know-how. But those people, just as much as they might be American citizens, they might be foreign citizens. And when they are foreign citizens, corporate counsel and people in the C-suite need to think about what are those consequences and what should we do in advance and after the deal closes. So the consequences are that the person who you might think, or the group of persons who you might think are the most valuable, oftentimes will need to get permission from the U.S. government, from the Department of Homeland Security, to allow them to switch employers. Because often when there is a corporate restructuring, there's a new employer and the individual will get a new paycheck with a new federal tax ID number on it. And it's not automatic because few people realize that permission to work is tied to a sponsor. And if that sponsor changes, something has to be done, or else there will be a gap in employment authorization. And a gap in employment authorization, if it's not realized, can make the individual deportable, as well as their family members, and it can cause the employer to be fined for employing someone with knowledge that they lack the right to work. When an organization hires an individual, they have to do, for anyone, a citizen, permanent resident, foreign citizen, they have to do a Form I-9, which is an employment eligibility verification in which they confirm the person's identity and they look at original documents to make sure that the person has the right to work. Well, when there is a corporate restructuring and a new employer comes into the role of employer of that individual, so there's a change of payroll and now there's a new employer involved, that new employer has the right either to check the original I-9s of the former employer and accept them and accept the liabilities that might be there, or to do completely new I-9s and not worry about the predecessor's liabilities. So this is something that needs to be considered, and it will vary depending on the industry. In some industries where there is a high likelihood of unauthorized employment, not doing a due diligence inspection of the I-9s before the closing can come back to haunt you, because perhaps the people that you are about to take on, you will discover do not have the right to work. So it's important to be sensitive to those I-9 obligations and the choices available. Another thing to focus on is that the creation of a new structure may actually undermine the visa eligibility of the individuals, and they can't change employment. For example, there are a series of visas called treaty visas, E1 and E2, and those depend on common ownership by a foreign individual or company where they have a particular foreign nationality. That's because we have treaties. The U.S. has treaties with many countries, but not all. And if the majority ownership changes so that it is no longer British, for example, and now it is French, or it is Australian, or it is American, those British individuals who were able to come and work no longer can work. They have to find a new way and do it fast, and sometimes there may not be a way. So you want to think about this beforehand, and you also want to do the due diligence to make sure that the paperwork is in proper order, because the last thing you want to do is buy a pig in a poke and find that you're in trouble. The final thing is to recognize that when two organizations merge, it's not just the merger, it's what happens after that. And what happens after that is there has to be an integration of systems and an integration of cultures. And in the immigration sphere, oftentimes there are differing case management applications that track the eligibility and continued employment authorization of individuals. And which one do you go to? There may be two different electronic I-9 systems. Which one do you go to? You probably need to get some consulting on what's the best approach, or perhaps put out a request for proposal in order to do that. These are some of the things that often are forgotten in the flurry of activity around a merger, or a corporate restructuring, or an asset acquisition, or a spin-off. And so my urging to the corporate world is to remember to think about immigration even as you're negotiating the transaction, not after it closes.